Hi, I'm Melissa from Ashwood Solicitors, and today's video is on a brief guide to the litigation process in the small claims track. We're hopeful that this video would be helpful to any claimants, that's the people that are bringing the claim, and any of the defendants, that's the people who are having the claim brought against them, who are having to deal with the claim in the small claims process. Now, a small claim is a claim that's worth less than £10,000, and they're usually claims for debt. Other claims such as injuries and housing claims and even employment claims, any that are less than £10,000, there's usually different small claims limits, so it's worth just checking what your claim's for and the value of your claim before starting. Now, one of the things that you need to consider in bringing or defending a small claim is whether you need legal representation. Now, a small claim, which again is a claim that's less than £10,000, is deemed by the courts to not need legal representatives. Now, this is because, win or lose, you won't recover your legal costs from the other side, and therefore you need to consider, if you want legal representatives, that you would have to pay them on a private basis. Now, there's lots of things that you need to weigh up in considering your own personal circumstances as to whether you want to have a solicitor to help you with your claim. Now, one of the main things is the value of your claim. Now, if the value of the claim you're making or the claim you're defending is to the lower end of the scale, so a few £100s, it might not be worthwhile to instruct a solicitor, as the value of your claim may be outweighed by your solicitor's costs. Alternatively, your claim might be worth in the region of £10,000 or close to the top end of the budget, and at that point, bearing in mind your personal circumstances, you may wish to instruct a solicitor to help you. So all I would say is that look at your claim, whether you're making it or defending it, and then weigh up whether you would like to instruct a solicitor or to get some free initial advice on what your next steps are. Now, when you start a small claim, the first thing to consider is the civil procedure rules. Now, the civil procedure rules are the rules that are in place which will govern your claim from the start all the way to the end. Now, the civil procedure rules will apply to both claimants and defendants, and these can be found on the gov.uk website. Now, Part 7 of the civil procedure rules, which is split up into different parts, governs how to start proceedings. Now, how to start proceedings would be to do a claim form. Now, there's two different ways you can start a small claim. You can do it online with the Money Claims Online service, or you can do it with a paper form, which is the N1 claim form, which can also be found on the gov.uk website. There is a court issue fee that you need to consider, and there is a guide called the EX50, which will tell you how much the issue fee is compared to how much the claim is worth. You must pay the issue fee when you issue your claim, you send your claim form to the court, otherwise your claim will not be issued. In some circumstances, if you have a reduced income, you can also apply for a fee remission. To do this, you would use the form, the EX160. The claim form is fairly straightforward to fill in and to complete, but I would like to point out that it's worthwhile remembering that you need to ensure that the parties' names, their names and addresses that you put on the claim form are the correct ones, and also that you include all the details about the claim so that it makes sense and so that the person who's receiving knows exactly what you're claiming for. Once the claim's been sent to the court, whether this be by the Money Claims Online service or by your paper copy, the N1 claim form being sent to the court directly, the court will then issue and serve the claim on the defendant. The defendant will then have 14 days to acknowledge the claim. The acknowledgement of the claim is in the form called an acknowledgement of service. This will be attached to the claim form sent by the court in a response pack. Once the defendant acknowledges the claim by completing the acknowledgement of service, he would have a further 14 days to draft a defence. If the defendant fails to do an acknowledgement of service within the 14 days, the claimant is at liberty to enter judgment. If the defendant does do an acknowledgement of service but fails to do the defence within a further 14 days, so 28 days from service of the claim form, then the claimant is again at liberty to enter judgment by default. It's really important that if you wish to defend a claim, that you do a defence, you do the acknowledgement of service first, and then you do a defence. Now, to draft the defence, you need to have a look at the civil procedure rules and the content and what you need to include in a defence. If you look at part 15 of the civil procedure rules, it will have some handy pointers of things that you need to include and what must be there. It must contain a statement of truth at the end of the defence, and to find the wording of the statement of truth, if you look at part 22 of the civil procedure rules, it's laid out there. Now, once the defence has been sent to the claimant and sent to the court will then send out a directions questionnaire to the parties. This is a form called the N180. Now, this directions questionnaire is just a questionnaire of things to do with the case. So it will check the parties want to allocate the case to the small claims track. It will check how many witnesses there will be at the hearing, whether there's any need for expert evidence. But one of the most important things that it will also check is whether the parties wish to undergo mediation. In a small claims track matter, the courts have a free mediation service which they offer out as long as both parties agree to go to it. So if both parties agree to go to mediation, then you would be referred to the mediation service to see whether we can resolve any part or all of your issues. Now, if the parties agree to mediation and the claim settles, then that's where the claim will settle. However, if the parties do not agree, and the process will then carry on throughout the courts. The court will then provide the parties directions leading up to a hearing. The directions are usually something along the lines of the parties must disclose all the evidence they wish to rely on, including witness statements, and send those to the other side. So the claimant has to send them to the defendant has to send everything he wants to rely on to the claimant within 14 days of the hearing. The claimant will also be required to pay a hearing fee. There'll be a direction for this too. Now, the hearing fee, again, you can look up on the EX50. It will usually be included in the court order how much it is, but for small claims of less than £10,000, it will be no more than £335. There may also be a direction in the court order which asks the claimant to file a bundle of documents with the court prior to the hearing. If this is the case, the bundle of documents the court will require are the witness statements which have been exchanged by both parties, and also any documents which the claimant and defendant wish to rely on at the hearing. Now, at the hearing, unless you have instructed a legal representative, you will have to either present or defend your claim yourself. The judge will then give his ruling and the matter will be decided on the day. It may be worth considering throughout the proceedings, as well as at the beginning, whether you wish to instruct a solicitor to assist with any part of the matter. I would also like to highlight that it is actively encouraged for the parties to try and negotiate and resolve any matters. So if you as the claimant or you as the defendant wish to put forward an offer to the other side, you can do so throughout any part of the court proceedings. I would say though, if you're going to put forward an offer, make sure you mark it without prejudice so that it doesn't get shown to the court until after the ruling. Now, I hope this video has been helpful to you, and I hope it helps if you're looking to bring a claim or if you're looking to defend a claim. We would like you to please like and share our video, and if you've got any legal queries, especially ones whether you have a matter that's worth £10,000 or less, or one that's £10,000 or more, please contact our officers and we'll be able to give you some free initial legal advice on what your options are. Thank you very much for your time.